Angus. I'm from Red Union Group, and this is Ben, also one of our case managers from Red Union Group. On the line over there, we've got Miles from Worker Law, and starts to go. Let you introduce yourself, Miles.
That's everyone should be muted now. Looks like we're back on track in the winner's circle. Wonderful.
Cool. All right. Yeah, so we understand that there's been a couple of questions posed just beforehand, which Miles has in front of him there. So I guess I'll let you take the lead.
Well, good afternoon, everyone. My name is Miles Heffer, and I am one of the industrial officers with the Red Union Group's multiple unions. The question with relation to this matter, it also is, I've got one in my diary for immediately after this as well. And so, hey, sorry, Mel, could you just, sorry, they're just on a video and it's also, could you please go? Sorry, thank you. Thank you, Mel. I've got one in my diary for immediately after this as well. So, but I'm not sure if there is one as well. Angus, is that the case?
Yeah, there is, but that's for general Red Union members in Victoria rather than police specific. So.
Now, what I wanted to talk to you about first of all was the broader position. Now, I appreciate that there are police officers from Queensland, some police officers in New South Wales, and police officers in Victoria. The first and foremost thing that we need to be able to do is to be able to realise that each state has different components, and there was a Supreme Court matter in the Queensland jurisdiction today, and so some of the orders have not yet been published, and the Queensland Human Rights Commission has intervened on that, but I don't have the benefit of reading those submissions as of yet, or what little has been filed. So for Queensland Police, it is a moving feast. There is a separate legal action on foot, as I understand it, will be before the Industrial Commission on Thursday, turning on some of the similar facts. So what I'm trying to break down is what we can do, first of all, if you're facing being fired versus every other step. If you are facing being fired in every state, the advice is the same. You must have by now asked to look at the risk assessments of the various occupational health and safety requirements and attempted to meaningfully engage with your employer on that. If you have not done that, you must, as a matter of course, do so. And if you do not, then there are some serious concerns. Yes, this is a police one. The next one at an hour later is for general people. This one is a tailored one for the police service and police officers. So if you're a sworn officer in Queensland, some of this information may change as early as Thursday, as there is also a separate full bench decision or a full bench trial coming up in industrial dispute, which is incredibly unorthodox in the time frame. So it might be that it's for the Queensland Police that we need to revisit this on Friday, Angus, and once some decisions have come out. However, what we do know is that this matter of law is that it's untested as far as an employer not being able to conduct risk assessments. The risk assessments process is critical. And yes, some of you might have written 1, 2, or 3 letters. It is not the case that an employer ignoring it hurts you, it hurts them. Now, as a police officer, more than ever, you know about risks and whether they are then trying to stand you down or sack you. And in New South Wales, that's known as victimisation under the New South Wales law. Under Queensland and Victorian law, that is known as adverse action and could in fact contravene other areas of the law as well, under workplace health and safety laws, as they're referred to in Queensland, or occupational health and safety laws. So first and foremost, if you haven't sought risk assessments, do so as a matter of course. We recommend the template. Now, if your boss is asking about your vaccination status, it is a private piece of information as a starting point. Your bosses are in fact also requiring that they're almost doing a league table where they're saying who has and who hasn't. If you're in that situation, you're going to need a different level of response than if you are not. It is important if you are seeking an exemption, however, that you assert your right to your privacy, not refusing it, but saying while you are currently assessing the process, it's too early to provide that information. The question if members face disciplinary action because of the refusal and what action the union can take. I need to be clear, we're not refusing anything. We are asking for risk assessments. It is your employer that has refused to deal with you. Now, regrettably, the employer is taking a heavy hand, as you would know. They're fighting two battles in both the Supreme Court and in the Industrial Commission as a full bench on Thursday in Queensland's case, and similar cases in other states. Some officers have already been terminated in New South Wales, and we've got 21 days to run dismissal claims for those persons. So if you are threatened with dismissal and you have communicated in the method we have proposed, which is that you are ready, willing and able to work, and you are facing a show cause process, it is critically important that we communicate with your employer about that and respond to the show cause. Now, there's only so much membership includes, and I'm not wanting to sound like a negative Nancy on this, but for those that have paid for a fortnight's worth of dues, we cannot write a bespoke and tailored litigation strategy for you as part of that when there are so many members. So we've got some template responses for you to pick and choose from, and there will be more coming up overnight to respond to those different scenarios that you've got. If you do need tailored service, though, it might be that you do need to see a private industrial advocate or a private solicitor on this immediate one if you have an urgent requirement. However, the template responses that we've got are covering the field if you followed the other areas. And if you're in the middle of disciplinary action, we obviously need to get in front of it before that disciplinary action response date is due. And so it's important to communicate back with the response date. But if your response date is prior to next Monday, it is highly unlikely that we'll be able to respond other than in a templated response with the amount of volume that's there. If you are stood down without pay, it might be an underpayment claim. It's better to be stood down without pay than to be fired, because then we are chasing for your underpayments. If members are sacked, we've got 21 days to pursue those, and depending on the type of dismissal is and what led up to it, and we can assist members that were not pre-existing with pre-existing issues and with that, and we can provide some services to those, but you also have the right, of course, to get your own private representation. There is a question here, which is an important one. What if you're talking about pretending to get vaxxed? I go into this next line cautiously, being I'm on the communicating with a bunch of sworn officers. Obviously, that could be fraud and or another form of misrepresentation that could get yourself dismissed for another reason. Remember, we are ready, willing and able to work. It is your employer that is locking you out in a form of reverse strike. So if your boss is proposing to take leave or whatever, it may be that in the short time that you do take your long service leave or your annual leave, that we fight that. But we say we're taking it under duress, and we can help you put the right communications to it, because I appreciate you, you've got to feed your families, you've got to pay your mortgage or your rent, you've got to pay your car loans, and therefore it might be essential that money is coming in. And then we look at whether or not that is unlawful industrial activity or another unlawful direction under the relevant award systems under state or federal law, and sue for underpayments, sue for award contraventions, etc. You absolutely ought not to use your work email to contact us. And I guess in the same way that you would love an accused to be potentially copying their emails to you, you don't want to know that. So it's better that you communicate and have a private email. But if you do need to set up a Proton email or on Signal or on or Gmail, etc., then that is the best course of action that you can take. With the next steps, if you've got all the letters out and you're facing a show cause in the next 5 days, it's essential that you alert Red Union's respective people to that. but we are trying to get through the ones in priority. It would be of great assistance if you could put in the subject matter the response date that is due. And the first thing is to try and seek an extension until next week. If you could seek an extension until next Wednesday for any response as a matter of course, that would be incredibly helpful. There are thousands of claims between the 3 states. Now, if it is the management replies are following something that is an unusual step, then we may need to give bespoke advice. However, we do have processes in place if the advice is around a show cause, if the advice is around a stand down, if the advice is around a forced leave, all of those scenarios have been covered. I do strongly encourage that you CC Red Union in on your correspondence, but it may only get saved to your file. You CC the hotline email, but we might not be able to action it in the next excuse me in the next 5 days. And we do have teams working all over the weekend to try and overcome the excessive amount of demand. The standing down is a misnomer if you're ready, willing, and able. Your employer is actually stopping you from working. It is not a stand down. And the reason is it is not a stand down because the stand down is where there is a stoppage of work, and clearly there is no stoppage of work here. You are in essence being suspended. Your employer is sometimes characterizing as a deliberate behaviour. Under state law for Queensland and Victoria, that means considering your human rights. Those human rights to privacy, human rights to forced experimental treatment, and the human rights to fully informed medical consent. And separately, there are adverse action claims in the state of Victoria and the state of Queensland as well. So please don't call it, if your boss is calling it a stand down, that is not the case, because it ain't a stand down. Are there anything you can do whilst members are on sick leave? Now, if you've been on forced leave because it is stressing you, then yes, there are steps that can be taken. If you are truly sick, then of course you can attract sick leave. If your boss is saying that you can't attract sick leave, we might need to look at your personal circumstances. But if your boss is giving you a medical certificate saying if your doctor is giving you a medical certificate saying you are sick and your boss is disputing that, while it might require a tailored or personal response, at the face of it, it's not for your boss to approve sick leave. What a lot of bosses are doing though is not approving annual leave or long service leave to starve you out. So saying, oh yeah, no, you can take all your leave you want, you just can't do it. But then saying, oh, by the way, we're only going to approve a week's annual leave and then you can fend for yourself. In other words, they're cruelly trying to drip you out or starve you out in a way. That may give a trigger to multiple different industrial causes that you ought to take strong attention to. Now, I will throw, and I'm sorry for Jack throwing you on the bus, this is why people who join up not getting the welcome letter and the letter of instructions. I expect, so sorry, Jack, welcome to the party, and there are you under the technical bus to start with.
Yeah, sorry, no, that's all right. Can everyone hear me? Sorry I'm late, I got caught up at another meeting that I shouldn't have been, but anyway, my understanding is they have all gone out. Angus reckons they have gone out. Maybe check your spam folder to see if they're in there, but certainly if it isn't the case, then Angus will follow it up.
It may depend on your provider. So if you're with Gmail, for example, it may be in promotions or something like that. Just drag it into the inbox to make sure you get it. But I went through and had a look at all of the emails that have been sent out, and it looks like the amount that have gone out align with the amount of SOPAA members we have. So I'd really encourage you to check your junk and check your promotionals inbox.
And the final question, does Command know that we are being represented by Red Union officially? So each Red Union is a coverall brand to assist multiple industrial associations that have their own separate legal persona. So the Sworn Officers Police Association is distinct from others. It has its own legal entity, and it is a member-based organisation to protect the interest of sworn police officers. You ought to exercise those rights to be represented by your industrial association. And again, you will see our Victorian and Queensland friends, you have better rights there than you do in New South Wales. However, New South Wales does have laws that protect those that are exercising their rights to a safe workplace, and separately their rights under the industrial relations laws to be protected and to be represented. Alrighty, so I think that answers most of the questions that are on my list, and so now we can do a quick Q&A. But 1 second. So, is it so? Angus, is that what's happening now? Sorry, this text's been a bit rough on this one, so I'm we're a little bit more disjointed than normal.
If people want to, we'll start going to the chat. The questions there. Why isn't that answered? Can you please okay. Scroll down a bit more. Can you please scroll down? Have received a response from direct line manager in response to second risk assessment letter saying that there is a request to get vaccinated is lawful given the CHO and Victorian Premier directions. Not sure how to proceed after this.
All right. So if you've seen our letter, the directions, there's direction 4, direction 6, and workplace direction 51, all which need to be read together. For the purpose of sworn police officers, it is the standard direction that they're referring to, and also direction 51. They are not to be read in isolation. If your boss is being dishonest about the fact that it's a direction and a direction stands, that helps your case. If you're facing imminent discipline, we need to deal with that separately. But it is plainly simply not true that direction 51, workplace direction 51, does not exist. You've seen the templated documents that are online that make it very clear. For those of you that haven't provided that to your employer, if your employer is saying that the direction stands no matter what, give them that document. If they say that again, well, we can do another templated letter. The first response is, absolutely, have you read that last letter? Now, there's 2 distinct paths that are going on the materials you've been provided. One is the step 1 through step 2, step 3, and step 4, which some of you are referring to. However, there is a separate one, which is the urgent direction 51 consultation. So if you are escalating there and you haven't given the urgent direction 51 consultation, which is online in your area, that's the next step. So now, Angus, you'll be able to do a live link to that one, will you, on the direction 51 for the police? Or can we drop that into the chat, or would you like?
Yeah, I can arrange that.
Okay. Angus is our technical expert today. What we will do is in the live chat get that to you, or Jack's actually coming back, I can see, so we'll do that. So, all right, so there are the questions for the police. I'm now speaking to Victorian Police. While there are step 1 and step 2 and step 3 consultation processes, on Sunday night, we published a direction 51 urgent request. That comes in priority of everything else. It is an entirely comprehensive process for Victorian law, for the Victorian employees only, which are covered by the Fair Work Act. So if you have not sent that direction 51, urgent one, you must do it. There is a separate document for people that are employed in the construction, the residential aged care, the healthcare industries, and education, which has 1 additional paragraph, right? And as a consequence of that, you should have sent that one out if you are there. If you have not, then please send that one through. Those of you saying you can't find it, I will leave the team at the member support to help you. It is a public document though. It's not behind a paywall. So if you haven't got your Direction 51 letter out for all industries other than education, residential aged care, healthcare, and construction, then that is your next step, irrespective of whether you are not doing it. So someone's saying the letter 51 only can cover the construction. There's two documents. There's an additional document that covered those industries. There is a standard one as well. And so I'll get the Red Union team to assist you with that. But that's a critical document. Now, technically, because of the orders in Victoria, that sits distinct of those steps of 1, 2, 3, 4, because it's entirely focused on Victorian law area. Now, if you are away from work, and it's Direction 51, by the way, everyone, not Section 51, and Angus is going to chuck them up. If you are away from work for other reasons, you should still send the Direction 51 urgent correspondence. I think I've answered all the questions, Jack. I don't know.
So what I'm going to do is I'm going to post not only the initial steps in a link, but then I'll also post the that letter link. So if everyone just keeps an eye on the chat for a second, we can go through those. Sorry. All right. So there's the workplace health and safety steps info initially.
I just don't confuse the steps, Angus. Just Direction 51. Sorry, I don't.
Okay.
It's really important. Please not the steps for the moment. Sorry to be a pain.
That's okay. And then here is sorry.
Don't need it because we don't need the construction. This is the police one. All right. So that one is there.
There we go. There's the link.
Someone just sent us a message saying there's so much information to process. Can this be replayed? My understanding is it's being recorded.
Yeah, it's being recorded currently, and we'll post the footage later on.
And email that to members. So again, if you're not getting our emails, check your spam because it may be going into there or junk or something. But we will be sending it out.
And no, the stage 3 letter is different to the Direction 51 letter. And it's really important. The stage letters are really important for standard safety. The Direction 51 is a different document which is not staged. It is a critical document up to date to deal with the most recent CHO directives in line with Section 200 of the relevant Public Health and Wellbeing Act in Victoria. Yes, in answer to your question, Rebecca, stage 3 and Direction 51 is the perfect crime. Forgive my police pun there, Jack. Send them all, send them both. But critically important, any employer that is saying the direction stands on its isolation, it is the least we could do to educate your employer that Direction 51, which is Workplace Direction 51, is to be read in conjunction with it. Okay.
Someone just asked if Directive 51 is the same as the stage 3 letter. No.
No, it's similar, but the Direction 51 letter enlivens a number of laws. Okay, can we, those that are getting your welcome letter questions, and I apologise for the administration ones. What I might do for those ones is, if there's any other legal questions that are there, I'm happy to help with those. I'm not able to assist with the technical ones. So the answer to Direction 51 is universal for all industries with the exclusion of residential aged care, construction, healthcare, and education, and that has a separate letter. And that we're meeting next in 26 minutes on that one. This is a police one. Okay. So Jack, I think we're now at the administrative questions. Unless to say, looks like it's all on the operation of the website.
Yeah, okay. I was just going to give a quick update too, just in regards to Victoria. We've been working, I've been speaking to Crystal, Crystal will call back, Crystal maybe even on the call, trying to very quickly mobilise to do something in Victoria in terms of a judicial review or some sort of collective action. I understand that the Victorian Police Division have been very successful in raising some money. Please bear with us. I know there's not much time remaining, but we are throwing the kitchen sink at it. And Angus is the best man to chat to about the website problems.
Yeah, well, it's my understanding that most of them have been fixed. If you still are having problems with it, send it through hotline. Let's get back to the law though. Miles.
If you've told people about your vaccination status, the genie's out of the bottle. It is what it is. It doesn't affect you one way or the other. If they pick on you for that, then let us know and we can assist you with that. If a police officer has been fired, we have 21 days to seek redress, and that's a critical time, a moment in time. 21 days is the maximum. The best time to act, though, is to try and put your boot in the door prior to any response being asked of you, and particularly if any response is being proposed that you're acting deliberately with misconduct, that you're intentionally refusing a direction. They are the ones that are the most mischievous and the ones that we need to address the most and quickly. As I've said to you, though, we are 5 days out from processing emails. There's over 4,000 emails that we must get through. We are trading all over the weekend. And so, yes, now, this is for Direction 51 is for every employee who is legally employed in the state of Victoria. It is entirely irrelevant to anyone outside of the state of Victoria.
I'll keep going through the questions. Can you please tell us at some stage if they have a right to terminate us and if we actually have anything to stand on as it is a CHO directive? Also, Fair Work told me that they can still terminate us when the time comes, even if on leave.
So one of the questions about termination is if it's an unfair dismissal, it's the definition of whether it's harsh, unjust, or unreasonable. And one of the tests of that is a concept called capricious. Capricious is if the employer is acting meanly. Now, there is a 2-to-1 decision of the Fair Work Commission about a different sort of vaccine and very specific conduct of the person who made that claim. As a consequence of that, we say those facts stand on themselves and it's not a precedent case. But your employer could stand you down without pay with no need to fire you. There is no need to fire you. At the very least, they could keep your job open to you and give you leave without pay, even if it's not something that is ordinary. But if they didn't, we'd be saying it's unfair because they could deal with it. Now, and so the first thing is it should be leave without pay, not dismissal. And if they're firing you because of an intentional behaviour, when it's not, then it could also be unlawful in the form of a general protections claim in the various states. Now, bear in mind, the police in Victoria have its own disciplinary processes, so I'm talking in broad terms as to how to press those. Okay, anyone saying your boss refusing sick leave? Your boss doesn't, sick leave is your application process, not your boss's. If you've got a medical certificate saying you cannot work and your boss is refusing it, we would need to look at your personal circumstances, but that seems unusual because it's not yours to deal with. As we're saying, you're ready, willing, and able to return to work.
There's none there. I've sent my third letter to my employer. Manager requested to speak with me, and I did. Was advised being vaccinated is a lawful CHO directive, and that no risk assessment is necessary. Left in the lurch. What next?
Yeah. So by that logic, the Chief Health Officer could also issue a directive as to only having carrots in the fridge for lunch. Is that right, Angus?
No.
Carrots are horrible things, they're healthy. What a load of bullshit. The Chief Health Officer cannot direct a private organisation. There is very strict rules, and I guess the Direction 51 letter that we have provided for you has 4 pages of information for your employer. If after receiving that, they are genuinely pressing that point, then they should put down their fucking crack pipe and have a proper chat with you, because it's not real. Am I allowed to say that to police officers, or does that get me in trouble?
Probably.
Sorry, police officers. I'm sure none of you bosses have a crack pipe.
What if I'm already on short-term sick leave for an unrelated matter without access to work email? Do I send it from my personal email? Yeah.
Yes.
I strong advocate for personal emails.
Then you'll have a record of it too. If they try to play silly buggers and lock you out of your emails, you've still got a record of it. So
I'm on rec leave, not sick leave, but they've spent all day chasing me and I have 48 hours to comply.
48 hours?
Yeah.
We look, if you are a member, if you've been a member with a pre-existing, if it's not pre-existing, please stalk member support and put that in your subject heading. If it is a one that you've joined and that's been over your head, then I'll leave it to the team to the best it can deal with. Critically important, it is much better to be on leave without pay than to be sacked, but we need to stick our boot in the door prior to it. So the cases we have to prioritise first is where there is imminent dismissal in the next coming days. And then we're triaging it with the view that we get through all of the emails by Sunday.
Basically, we can only have leave without pay and annual leave.
Well, the leave questions are ones that are important. Your boss can approve. You've got to have consent on annual leave. Leave without pay doesn't exist in the Fair Work Act, so it's about reasonableness. And finally, sick leave, if it's yours, it's yours. Now that important, someone made a really important question there, that you've gone to your boss and your boss has gone, I'm not your employer. Under safety law, your first up manager is the place to go. So then that's when you escalate it. And that is that escalation process that some of you also have taken advantage of. First letter, then to your boss's boss, then to your boss's boss's boss, etc. Right? So that's actually the order of events. Technically, your boss can't brush you off, but the poor bastard probably doesn't want to deal with it. And so that's probably fair enough.
There's another here. Where are you guys up to in becoming a registered industrial organisation? But I might throw to Jack for that one.
sure. We have no plans in becoming a registered organisation. I guess there's 3 tiers of unionism. There's a trade union, which is a very, very low bar. Pretty much everyone can be a trade union, and that's dictated by the International Labour Organization conventions. I think it's CO 98 and CO 87.
Jack, I'll be unemployed soon, mate. You've nailed them.
Basically saying that workers can unionize together without government interference and subject only to their own sort of rules, being the union's rules. So that's been incorporated in the Fair Work Act, which is, and then also the various state levels as a trade union, and federally defined trade union very broadly. Next rung up is industrial association, which you just have to have as a principal purpose or as a purpose, the protection and ongoing, as a principal interest, the furtherance or protection of workers' rights, something like that, which we satisfy. Industrial association. Registered organisation is above and beyond. It allows you to be a party to the agreement, get right of entry, which means you can inspect the wage and time records of everyone, regardless of whether they're a union or not, a union member or not, which we don't want and don't need. And we think it's offensive that unions can get access to people's records, even though they're not in the union. And the right of entry stuff also allows you to sit in the break room to drum up membership, which we don't necessarily need. So in order to bargain and sit at the table for bargaining, we just need to be appointed in writing. So there is no need for us to become a registered organisation. We don't want to do it, basically, and we won't do it, is the long and the short of it. Don't need to. We're an industrial association. It carries with it treats and protection of members and the regulation of poor behaviour. That's all we need.
Anyone talk about registered industrial associations, industrial organisations are trying to drag you into their swamp. They're trying to say that because by definition there can only be one one registered organisation that deals with one industry type. There's obviously crossovers for the big industries. All they're trying to do there is show that their privileged monopoly position is one that they want to hang on to, and so registration is their ticket. the Industrial Relations Minister here in Queensland did something similar today in Parliament, and I noticed that 2 weeks ago she sat there talking about vaccines in a QNMU t-shirt. So just because someone's saying something ain't true, even under the coward's castle, don't make it true, right? So just don't get caught in that swamp. You guys are doing a fabulous job of collectivizing. You are doing a fabulous job of working together. I've had the privilege in the last 3.5 weeks, 4 weeks, to see nearly 4,000 correspondences going back and forth, watching employers start by running ducks and drakes and finally pulling their finger out and engaging like they should have. The Industrial Association has launched Supreme Court proceedings here in Queensland. Other industrial associations that are not registered have commenced legal proceedings in other places. Fair Work has long acknowledged industrial associations as being able to bring claims on behalf of its members in certain areas. So just don't listen to that bullshit, because it's fundamentally bullshit. Otherwise, it's bullshit, Jack, and bullshit. But outside of that, I don't have a view on it. Other than it's bullshit.
Okay. Question about members. I think we're up to about 300 SOPAA members, is my understanding. That's growing very quickly comparative to our other unions when they first started. But also just be aware too, you're joining the strength and the collective of over, well, almost 12,000 Red Union members now. So we do have some resources to have a fight, and we will be doing that. So you know, you do have strength and protection under our umbrella.
And Jack, I do apologise. I know back in 15 or 14 minutes, the next one, I have unfortunately a very urgent matter I must attend to before 5 o'clock Queensland time. Please excuse me for bolting at this point, but I will run and be back. Those of you got the other questions, some of these that are not to do with police officers, you are most welcome to revisit at 5 o'clock Queensland time, 6 o'clock interstate. So sorry, Jack, I'm going to go.
No worries. Thanks, Miles. I was going to say that maybe even a better course of action may be to funnel your questions through John. You all should know John from Victoria. He's our president of SOPAA, and then he can funnel them through Ben, and we can get a lengthy answers for you if you have a number of questions still. But we probably have to go too soon in order to prepare for our next meeting, which will be focusing mostly on Victoria. But as I said, if you have questions, go through John. Oh, thanks, John. John just put his email in the chat, and then yeah, we can go through there to answer those questions. The link for the next meeting, funnily enough, is this one. We'll just be we'll shut off our camera for a bit. We'll kick you all out at sort of, you know, in 10 minutes time, and then we'll reconvene closer to 5. And you can jump back on or jump into the waiting room to wait for that one. So yeah, meeting at 6 o'clock. Yeah, so it's almost 5 o'clock now. It's sort of 10 to 5 Queensland time, and we will kick off at 5 o'clock Queensland time. So in about 5 minutes time.
Sweet. I see just there's a couple of people asking, saying that they're not police that are in here that aren't a part of our union yet. I saw one for retail workers. I'd encourage you to go to www.redunion.com.au, and then you'll see our selection of associations there. If there's one that's applicable to you, feel free to join that. If not, we've just started up a
Miscellaneous Workers
Union called the Independent Workers Union of Australia. Feel free to join that. And
great. Yep. Sophia, do you want to just drop that in the chat, and we'll here we go.
Right. Thank you very much, everyone. Just keep an eye on that link, and then